India Legal presents Courts Roundup.
Hello, I'm Hishay and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here's the headlines. Congress MP from Kerala moves Supreme Court against Farmers Act, contends that opening of unregulated parallel market would lead to exploitation of farmers. As government seeks more time to file relevant documents, Supreme Court adjourns hearing on pleas seeking extension of moratorium period, waiver of interest in view of corona pandemic, now hearing to be held on 5th of October. In hearing of extension of prelim exam, UPSC tells Supreme Court that it is impossible to defer UPSC prelim exams further as it would hamper objectives of the exam. Delhi High Court issues notice to Delhi Govt appeal against stay on direction to private hospitals to reserve 80% ICU beds for COVID-19 patients.
India Legal presents Courts Roundup.
The Supreme Court has adjourned to next Monday the hearing on pleas seeking extension of COVID-19-induced loan moratorium and waiver of accruing interest. On the last day, the centre had informed the top court that an expert committee at the highest level has been constituted in order to take a decision on the issue of moratorium extension, interest during moratorium and interest on interest and other issues.
The Supreme Court has allowed the government one more week to come up with a plan on loan moratorium to ease the financial burden on borrowers during the coronavirus crisis. The top court, which had asked the government to submit its plan on September 28, deferred the hearing till 5th October after government sought more time. The three-judge Supreme Court bench was hearing a batch of petitions seeking a waiver of interest on deferred EMIs during the moratorium period, which was introduced by the Reserve Bank of India to ease the burden on existing borrowers in wake of coronavirus pandemic-related restrictions. Some things are beyond my control, Solicitor General Tushar Mehta, representing the centre and the RBI in case, told the Supreme Court seeking more time to submit the government's plan. The decision on the matter is at an advanced stage and some more time is required to present the detail before the court, the centre's counsel told the Supreme Court. In its September 10th order, the top court has directed the government to submit the plan detailing the compound interest to be charged and any resultant impact on the credit rating of the borrowers, stating that the plan must be presented in September 28th hearing. The centre has set up an expert panel under former Comptroller and Auditor General K. Rajiv Maharishi to look into the issue of interest being charged by bank and on installment deferred during the moratorium period due to COVID-19 pandemic. In some relief to stressed borrowers, the Supreme Court had ruled earlier this month that loan account of borrowers availing the moratorium or a delay in loan repayment will not be declared as bad loan till further orders. The borrowers need to be protected and banks should not take any coercive action against them, the top court had held. A number of associations representing sectors such as bank and real estate developers are part of the hearing, while the petitioner demand a waiver of interest on interest for exercising the option to suspend EMIs due to COVID-19. The government is of the view that writing off interest will weaken banks and affect economic conditions. The Centre and the Reserve Bank of India have told the top court that the loan moratorium can be extended by up to 2 years on account of the coronavirus-related situation. The Reserve Bank of India had in March granted a 3-month loan moratorium due to the pandemic-induced situation and later extended it till 31st August in May. Bureau Report.
Congress MP in Lok Sabha T.N. Prathapan has moved the Supreme Court challenging the constitutional validity of Farmers' Empowerment and Protection Agreement or Price Assurance and Farm Service Act 2020. The plea filed through Advocate James P. Thomas challenges the Act as violative of Article 14, 15 and 21 of the Constitution of India. It is submitted that the legislation has been hastily passed without having adequate discussion on it, and some of its provisions are in fact against the basic structure of the Constitution and fundamental rights of the farmers. Further, it fails to establish farmer-centric courts where the farmer can raise their grievances similar to the ones created under the Labour Act, Consumer Act, Family Courts Act, etc. Instead, the Act gives the responsibility to subdivisional magistrate who already has multiple other duties and functions to perform. The ground taken in the plea are listed below. Definition of farmer under the Act does not identify the labour, tiller, sharecropper working in the farm as a farmer. The use of word predetermined quality in definition of farming agreement is a recipe for disaster. The standard used for farming produce may be more profit oriented and the parties involved may overlook the environmental impact as such standards. The Union Public Service Commission has informed the Supreme Court that it would not be possible to defer the UPSC preliminary exams beyond October. Advocate Naresh Kaushik, appearing for UPSC, informed the bench of Justice A.M. Khanvilkar, B.R. Govya and Krishna Murari that it was not possible to defer the prelims beyond October 4, as it would hamper the objectives of the exam catering the four arms of the government. It is impossible to agree to petitioner. It was supposed to be held on 30th of September. Thereafter, it was deferred to October 4th. Deferment would nullify the objective of conducting the exam for four arms of government. The three-judge bench has now asked UPSC to file an affidavit in reply to the plea by tomorrow so that the case can again be taken up on 30th of September. The petition filed through Advocate Alka Alok Shrivastava urged the court to quash the revised calendar issued by UPSC, seeking postponement of the exam by 2 or 3 months till the COVID-19 pandemic has subsided. Earlier, the bench of Justice A.M. Khanvilkar and Sanjeev Khanna had granted liberty to the petitioner to serve an advance copy of the plea to UPSC and the central government. The petitioners have stated that the decision of UPSC to conduct the exam violates their right under Article 19(1)(g) of Constitution to practice their chosen profession, occupation of serving the public. Citing risk of illness or death, the petitioner says that they may not be able to appear for the exam on 4th of October. It is further stated that the decision of UPSC fails to meet the necessity prong of the test of proportionality. A plea moved in the Supreme Court seeks direction to the centre to issue comprehensive guidelines with respect to online virtual classes through video conferencing for children, as there could be a threat to them exposed to obnoxious materials available on the internet. The petition filed by Dr. Nand Kishore Garg through Advocate Shashank Diyosude seeks order from the top court so that online classes can be immediately discontinued until the formulation of comprehensive guidelines for the hosting of online classes is in the completely encrypted and safeguarded manner. Raising concern that there is a growing risk of children falling prey to cyber predators, the plea states that the current lockdown-induced online classes have the potential to expose them to pornographic content or predatory cyber hackers. Further, the plea avers that appropriate direction should be given to the central government, the HRD Ministry and the CBSE so that robust cyber applications are developed on the pattern of the online exams being conducted by various agencies with specified softwares, which does not allow any other cyber application or the possibility of the pop-ups in any other window during the course of online examination. The plea also urges for the court to direct the respondent, including the center, to evolve a proper mechanism to make sure that children of economically weaker section of the society have access to these classes by ensuring computer devices for them. The petitioner highlighted that many children from poorer section of society have been completely discriminated when it comes to accessing online learning during the lockdown after school closed completely. Absence of motive in a case depending on circumstances. Evidence is a factor that weighs in favor of the accused, the Supreme Court has reiterated. The bench comprising Justice Ashok Bhushan, R. Subhash Reddy and M. R. Shah restored the acquittal of two accused, Anwar Ali and Sharif Muhammad, by setting aside the conviction record by the Himachal High Court. The duo were accused of murdering one Deepika. One of the contentions raised by the accused in the appeal before Apex Court was that the prosecution has failed to establish and prove the motive, and therefore the accused deserves acquittal in concern. In this regard, the bench observed it is true that the absence of proving the motive cannot be a ground to reject the prosecution case. It is also true, and as held by this court in the case of Suresh Chandra Bhari versus State of Bihar 1995, that it was also contended that even the recovery of a jeep from Chandigarh and recovery of photographs and the recovery of mobile phones belonging to PW7 from the jeep also create serious doubts. The court also noted that the investigating officer did not follow the procedure as required to be followed. Allowing the appeal, the bench observed that the findings recorded by the trial court were based on appreciation of the entire evidence on record, cannot be said to be either preserved or contrary to the evidence on record, and or it cannot be said that the trial court did not consider any material evidence on record. Therefore, we are of the opinion that in fact the circumstances of the case, the High Court is not justified in reserving the order by acquittal passed by the government learned trial court. We are now joined by Devanshi. Could you please update us on today's court proceedings?
Yes, in this matter, Honorable Apex Court has held that absence of motive in any case, depending on circumstantial evidence, is a factor that weighs in favor of the accused. Yes, although it is true that absence of proving the motive cannot be a ground to reject the prosecution case, but at the same time, absence of motive in a case, depending on circumstantial evidence, is a factor that weighs in the favor of accused.
Thank you, Devanshi, for the update. A petition in the Bombay High Court states that there is a lack of transparency in the way the Enforcement Directorate functions. The plea urges for direction that all ED cases information report and ECIRs and order refusing the registration of ECIR are displayed on the official website of the ED. On the basis of August 16 representation sent to ED, the petitioner and the advocate Ghanshyam Upadhyay states that no communication channel is available for common people to assist the agency with information, especially when nationalist patriotic citizens wants to approach ED to provide valuable inputs. The plea adds that when any investigating agency registers a scheduled offence as defined under PMLA, such agency should be under an obligation under Section 39 of the CRPC, read with Section 176 of the IPSC, to forward a copy of the FIR to the ED. This is so as to enable the ED to perform its own statutory obligation of examining such case to decide whether an ECIR would be registered for the plea. Further adverse that out of a few thousand scheduled offences and that might have arisen in the year 2020 itself. Nobody knows as to how the ED chooses its target and what is the basis of picking up a particular case for investigation or otherwise. The Delhi High Court has issued notice in an application seeking modification in the court's order on extending the interim bail granted to certain prisoners in light of COVID-19 pandemic. Moved by Public Prosecutor Amit Prasad, the modification is sought on the ground that certain prisoners convicted of heinous crimes are misusing the order of the court, which has automatically extended the interim bail granted to prisoners in light of the pandemic for another 45 days. The special bench of Chief Justice D.N. Patel, Justice Siddharth Mridul and Justice Talwant Singh has directed the Delhi government to submit an affidavit stating the total number of inmates in the central prison who are COVID positive. The state also has to inform the court as to how many prisoners have been released so far on interim bail and how many of such prisoners are due to surrender next month. Prasad, while moving the application, submitted that many accused persons first seek interim bail of 1 week on humanitarian ground and then never come back to the prison by claiming relief under the extension of COVID bails granted by the full bench of the Delhi High Court in a suo motu matter. Prasad further informed the court that 2 jails in Mandoli have been notified and as isolation ward for incoming persons. Prasad submitted these jails have a total of 248 isolation wards. At this time, the court asked the state how it will manage to isolate thousands of returning prisoners when it only has 248 isolation wards. In light of this submission, the court also directed the Director General Police to prison to be presented on the date of hearing. The court will next take up this matter on October 16th. Delhi High Court has issued notice in a plea seeking a direction to the issue of the Ministry of Health and Family Welfare to take stern measures to prevent subtle burning in the state of Punjab, Haryana and Uttar Pradesh in the light of COVID-19 pandemic. The division bench of Chief Justice D.N. Patel and Justice Pratik Jalan has issued notices to the Union Health Ministry as well as the state of Punjab, Haryana and Uttar Pradesh. The present application has been moved in a pending PIL titled Sudhir Mishra versus Union of India, seeking a direction to be issued to a respondent to use all measures to immediately stop the farmers from further burning the farmlands in the above-mentioned states in light of COVID-19 pandemic. The application has also demanded a team of experts to be sent to these states to ensure effective implementation of measures taken to prevent subtle burning. It is the case of the application that subtle burning may make the residents of the national capital more susceptible to the coronavirus. The applicant has further argued that since air is a public good, the coordination by the central government becomes even more pertinent. It is further contended by the applicant that the experts have shown concern by rising air pollution in Delhi with the simultaneous increase in the number of cases. The Delhi High Court has issued notice in Delhi government's appeal against an order staying its direction to 33 private hospitals to reserve 80% of ICU beds for COVID-19 patients. While the Delhi government pressed for a clarification to enable hospitals who are willing to comply with the direction to do so, a division bench of Chief Justice D.N. Patel and Justice Pratik Jalan said, "We are hearing the matter on 9th October and will see." Opining that prima facie, the order was arbitrary, unreasonable and violative of Article 21 of Constitution of India, a single bench had stayed the Delhi government's order on the reservation of 80% ICU beds for COVID-19 patients. The stay order was passed by a single judge in the petition preferred by Association of Healthcare Providers. The single judge bench had stated that the order would result in denial of urgent care to seriously ill non-COVID patients. In appeal before the division bench, the Delhi government informed that there was an extraordinary increase in COVID-19 cases in the national capital. Additional Solicitor General Sanjay Jain submitted that there were enough ICU beds for non-COVID patients, as only 33 out of 1,170 private hospitals and nursing homes had been directed to reserve ICU beds for COVID patients. While asking Delhi government to come back with data on ICU beds for both COVID and non-COVID patients, the court directed the association to file its response to the appeal. The court did not pass any interim order in the appeal. The matter would be heard next on October 9th. The Delhi High Court has ruled that a person who has retired as the director of company cannot be said to be in charge of the responsible for the conduct of the day-to-day affairs of the company as contemplated in Section 141 of NI Act for being proceeded against. The bench of Justice V. Kameshwar Rao was hearing a plea filed by an ex-director of the company Alibaba, Nabi Basa, praying to quash complaints cases under Section 138 of the Negotiable Instruments Act 1881, pending before the court of Ms. Alka Singh, Metropolitan Magistrate, South Delhi, as against the petitioner. In short, this petition was filed seeking quashing of 5 complaint cases initiated by the respondent number 1 against the petitioner herein. These complaint cases were primarily grounded on the return of 5 checks which were issued on behalf of the respondent number 2 of a total amount 45 lakh rupees. The proceedings were initiated by the respondent number 1, Small Farmer Agribusiness Consortium, against the petitioner Alibaba Nabibasa before the learned Metropolitan Magistrate. The court further observed if the document filed by the accused petitioner are beyond suspicion or doubt and upon consideration demolish the very foundation of the accusation levelled against the accused, then in such a matter it is incumbent for the court to look into the said documents, which are germane even at the initial state, and grant relief to the person concerned under Section 482 CRPC in order to prevent injustice or abuse of process of law. The Uttarakhand High Court has observed that for fair and peaceful election during the election campaign, party or candidate should not indulge in any activity which may create mutual hatred or cause tension between different classes of the citizens of India on the ground of religion, race, caste, community or language. An application was filed under Section 482 of the Code of Criminal Procedure 1973 to quash the charge sheet registered with police station under Section 125 of the Representation of the People's Act 1951, along with the entire proceedings pending in the Court of Justice Judicial Magistrate Chamoli. It may be noted that the election of the Legislative Assembly of Uttarakhand was held in the year 2012. The present applicant contested the said election from Badrinath Assembly constituency as a candidate of Indian National Congress Party. While contesting the said election, the present applicant had printed a picture of Lord Badrinath in his handbills as well as pamphlets. In the FIR, it was clearly mentioned that due to the act of the applicant, the religious sentiments of the people are being shaken. On the basis of the evidence found against the present application for his involvement in the commission of the crime, the investigating officer had submitted the charge sheet against the applicant under subsection 3 of Section 123 of the Act 1951. That's it for Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Courts Roundup.